Hello, everyone. My name is Jordan Alt. I'm a partner in Husch Blackwell's Jefferson City, Missouri office and chair of our firm's nonprofit organizations and religious institutions team. Thank you all for joining our program today. Before we begin, I need to cover a few housekeeping items. At the bottom of your audience console, there are a number of application icons that you can use during the program today. If you have any questions during the webcast, please submit them via the question box. I will be monitoring those today and will try to answer all the questions over the course of the next hour or so. If a fuller answer is needed, or if we run out of time, and we usually do, we'll do our best to answer questions later via email. I'll answer half of your questions now by letting you know that a PDF of the presentation is available in the program materials folder. The program has been approved for legal education hours. For live attendees, you can report your hours by clicking on the CEU icon at the bottom of the screen. Tomorrow, you'll get an email with a certificate of attendance, including course numbers, and also a handy recording of the webcast in case you want to watch it again or share it with your friends or colleagues. Toward the end of the program, be sure to complete a short survey. We use that feedback to plan future programs that are applicable to your business needs. And I promise we actually read those every single time, which is part of why we're here today. The subject of today's webinar is always at the top of the requests that we receive. That's it for housekeeping, so let's get started. I personally am looking forward to today's program because selfishly, this is a topic I don't know that much about, but I get questions about it all the time. Luckily, I know some people who are experts, and luckily for you, they said yes to helping with this webinar today. I'm going to chime in a few times to discuss just a slide or two about how some of these topics impact religious employers, because I know there's a lot of you on the webinar today, but otherwise, you'll be hearing from my colleagues Eric Eisenman and Michaela Hennessy. Eric is a partner in Milwaukee and leader of our firm's labor and employment practice group. He's trusted by clients for his practical and effective advice on workplace issues. He counsels employers of all sizes, helping draft and enforce employment contracts, restrictive covenants, other agreements, and he assists clients in various industries, including financial services, manufacturing, and healthcare. Michaela is a labor and employment attorney in our Kansas City office who understands the sensitivity and complexity of labor and employment law and emphasizes preparedness, compliance, policies, and training to prevent issues. She also monitors local, state, and federal guidance to implement best practices. And I'm lucky enough to work with her with a lot of our religious clients. So we divided this topic into two sections. The first is internal matters, and the second is external. Eric is going to take the lead on talking about how DE&I efforts impact internal matters such as employment, and then Michaela will discuss external matters, including funding and community programming, and I'll chime in with any questions that you raise at the end of each of those sections. So that said, Eric, I'm happy to pass the baton over to you.
Wonderful. Thanks very much, Jordan. I'm really excited to be with Jordan and Michaela today and to be with all of you who are attending. As Jordan said, this is a topic that we get lots of questions about from clients in many different settings. So I'm excited to be able to talk with this group today about it. Let's do a little bit of level setting. In my section of our presentation today, I thought that we could maybe talk a bit about some of these questions to consider. Some of them are probably familiar or on your list. How can we take steps to achieve our goal of diversifying our staff? Can we seek staff members of a certain age, gender, race, or sexual orientation that are otherwise missing from our team? How do we address staff members that don't support these goals? And then our board has a goal of looking like the community we serve. Can we recruit board members with that goal in mind? Today, I'll talk a little bit about the legal framework that we're operating in here, some examples of what we see as permissible or impermissible DE&I initiatives, given sort of the current legal climate around these topics. And then hopefully at the end of this section, we can talk about whether we can effectively answer these questions. So as I said, I'm going to start with a bit of the legal framework. There are some other, federal laws and state laws that may apply, but the big tsunami that we encountered more than a year ago now was the Supreme Court's decision in Students for Fair Admissions. You all are likely familiar in general terms with that decision, where the court ultimately held that the framework of affirmative action that was in place for many years here in the United States was considered in violation of the Constitution. So the court in that decision basically said that universities who were utilizing affirmative action to potentially express racial preferences were prohibited from doing so going forward. By its terms, that ruling only impacts educational institutions. Contrary to what you may have read or heard, there's nothing in that decision that directly impacts private employers, public employers, nonprofit entities. But I use the phrase tsunami because it had this large and wide-ranging impact. We are seeing fallout of this now, a year and a half plus on, in lots of different places, including in all of our employer clients, including those that are in the nonprofit context. Interestingly, immediately after this decision was issued, you had the EEOC, the federal agency empowered with enforcing anti-discrimination laws, put out statements on it. And to make matters more complicated for us, conflicting statements. So you had the chairperson, the current chairperson of the EEOC, saying that the court's decision in Students for Fair Admissions does not address employer efforts to foster diverse and inclusive workforces, and that it remains lawful for employers to implement diversity, equity, inclusion, and accessibility programs that seek to ensure workers of all backgrounds are afforded equal opportunity in the workforce. So that seems like a strong basis upon which we can rely to advise our clients that want to continue to invest in this area. The challenge is that, a different commissioner on the EEOC, one who had been appointed by the previous president, stated that the court's ruling should prompt employers to take a hard look at their diversity programs. So it's left employers in sort of a difficult position. And what we've seen flowing out of this is an increase in litigation, reverse discrimination claims, some of those that Michaela is going to talk a bit more about in the second half of our presentation today. An increase in awareness. I mean, this has become a political topic, as you all know, a hot topic in sort of this election season. The vice presidential nominee for the Republican ticket, J.D. Vance, is a co-sponsor of a bill that was introduced in the Senate called the Dismantle DE&I Act, which would seek to outlaw many diversity, equity, and inclusion practices in private employers that are government contractors. So that could have a pretty big impact sort of across the economy. And then also in sort of the sphere of public relations, right? You're seeing boycotts against companies like John Deere, Harley Davidson, Budweiser, by political activists who believe that investing in DE&I is inconsistent with sort of the mission of those organizations. So it leaves employers in a fairly unsettled space. Having said that, the legal framework for these sorts of efforts really hasn't changed. Again, we've got this Students for Fair Admission decision, but the actual law that we're reading and advising clients on is the same as it was 5 years ago. Race-based decision-making in the workplace has always been unlawful. That said, well-structured DE&I programs that do not run afoul of federal or state anti-discrimination laws remain permissible. And what we now see is that the Supreme Court has probably opened a door and made it more likely that we are going to see challenges against private employer DE&I efforts. So with that as a framework, I thought I would talk a bit about what we see as sort of permissible or impermissible internal DE&I initiatives. And these are just a sample of some that our clients operate currently. What we would see, given the sort of current framework, as an impermissible DE&I initiative, or maybe a better way to say it, would be an initiative that could create exposure or litigation risk to an entity, would be a mentorship, an internal mentorship or sponsorship program available only to women or historically underrepresented groups. These were not entirely uncommon. Large organizations would often have, particular programs that seeking to create advancement or opportunity for historically underrepresented groups. Under sort of the current legal framework, we have seen an increasing number of those programs serve as targets for either litigation or, as I suggested, political or public relations campaigns, arguing that expressing a preference or limiting participation in these sort of programs only to specific groups or classes is in violation of the law. So what we recommend instead as a permissible initiative would be a mentorship program or a sponsorship program that is open to everyone, but where, if you wish, you have women in historically underrepresented groups that are encouraged to apply. And let me put a fine point on that. You can specifically market this program, communicate this program, encourage folks who are in these historically underrepresented groups to apply. What I would suggest we would just need to do is make clear that we are not limiting participation to those individuals. A program like this can exist. You can market it in the way that you wish. But if an individual seeks to participate in that and they don't belong to one of those groups, their application should be given fair consideration, just like any other one. Another initiative that we see or that you may have are employee resource groups. We've seen a significant increase in these, either ERGs they're referred to, over the last several years. It would be challenging or problematic to have an employee resource group that is only open to minority employees or individuals in a particular class or race. Instead, our advice is to ensure that the employee resource groups that support specific groups based on class, race, status are open to all employees for membership. So again, this doesn't mean that you can't have a women's employee resource group, a Black employees employee resource group, an employee resource group for a particular religious affiliation, but you would need to ensure that those aren't exclusive, that an individual who may not belong to that particular class or doesn't identify with that class could still be entitled to participate in that. So you can still have those sort of initiatives and ERGs, but you need to ensure that those are open to all who would wish to participate in them. How about hiring policies? And this gets a little bit at one of those big picture questions that we're going to sort of struggle with as we sort of wrap up this section. It would be potentially problematic for a company to articulate a policy that has a set goal of hiring 45% women and 35% racial minority members in the coming year. However, it would be acceptable for a company to say, we have a goal and we are committed to equal employment opportunity and are setting aspirational goals to increase diversity hiring in this year. Or we're seeking to increase the number of women or people of color in our leadership. That remains permissible. What we want to avoid, and what I think this gives an example of, are scenarios where we're specifically setting a numerical quota. Again, I don't think this is entirely uncommon in the recent past. And I think there's an argument that setting a target that matches with the percentage is still permissible under the applicable law. But our best guidance these days is to focus on setting aspirational goals and avoiding those sort of quotas or numerical goals. So here are some sort of big picture recommendations that we have been sharing with clients. As I just said, you want to avoid using quotas or set-asides. You may be familiar with set-asides. That would be the idea that there's a certain number of slots or bids or contracts that are going to be available only to individuals in a particular group or class. Avoid that on a going forward basis. Instead, set aspirational hiring or advancement goals. A second piece of advice, ensure that you define diversity broadly. Diversity can mean lots of different things. There's certainly racial diversity, gender diversity, but there's diversity in age, there's diversity in economic status, there's diversity in geography, there's diversity in all sorts of different life experiences. And when we think about one of the reasons why organizations want to build diverse teams, it's because people coming from different backgrounds and with different life experiences are going to have different things to contribute to the whole. Defining diversity broadly and thinking about it as more than just race or gender is going to be a strong defense, I think, against a claim that this is in violation or that your efforts are somehow in violation of state or federal law. Focus on removing barriers in the hiring process. I want to draw a distinction. It is problematic for us to say we are looking, we talked about set-asides, we are looking to hire more Black employees, and so this is a position where we need a Black individual to fill this role. It would not be a problem for us to say we want to enhance our diversity in our organization, so we're going to be seeking additional places to recruit, to conduct interviews, to attract candidates, and maybe we want to begin focusing on historically Black colleges or other places where we're going to find diverse individuals who may not currently be in our organization. So thinking, I've heard the metaphor used before, finding other pools to fish in than we typically do. I think that's one of the strongest ways that you as an organization can increase diversity, is thinking about how we're sourcing our applicants, our board members, and thinking about casting a wider net. Creating mentorship and pipeline programs open to all employees. I used one of those hypotheticals, reference this again. To the extent that you've got those sponsorship, mentorship, pipeline programs in place, those remain fully lawful. We just want to make sure that they are not exclusive. And that although we could sort of encourage folks in specific groups to apply or participate, we should ensure that they are open to anybody who wishes to do so. You should continue to provide anti-discrimination and anti-harassment training. There's nothing about sort of the Title VII compliance or state anti-discrimination training that is now problematic under the law. It's a best practice to continue to do those. And I'll jump to the last bullet here before I hit the one before, but we need to make sure that we're taking all complaints of discrimination seriously, including reverse discrimination. So I alluded to this fact, and I think you'll hear Michaela talk a little bit more about that in a moment. But we have seen an increase in reverse discrimination claims. So those are individuals who maybe don't belong to a historically underrepresented group, arguing that the employer's policies are discriminating against them in violation of the law. As an entity or as an employer, you need to ensure that you're not sort of rejecting the claim that might be brought by a white male employee simply because you think that it's unlikely that he's experiencing discrimination. If those complaints come forward, you should follow your processes in the same way you would with any other concern, and take that as seriously. And I think that will effectively do a lot to protect an organization from claims. And then the bullet I skipped there, which is relevant to point out, you should continue to carefully review internal and external communications related to DE&I. So when we go back to some of those discussions about mentorship or sponsorship programs, or some of the things that Michaela is going to talk about when you think about sort of the external messages, we've worked with clients on a number of instances recently where we've modified the language that we're using to refer to some of those programs, or modifying the language that we're using internally about eligibility or participation to make sure that it aligns with what we're actually doing. We don't want there to be a communication either internally or externally about what our diversity goals or what our DE&I efforts are that are actually inconsistent with what we're doing. And I found that that's a place where some employers can get into trouble, where the materials that are out there about this program, maybe are outdated and they haven't been updated in the same way that the program itself actually is. So a big recommendation would be to ensure that that is aligned. Okay, so I've given a little bit of an overview of this area. Let me try to apply that to these specific questions that we posed for ourselves at the beginning. How can we take steps to achieve our goal of diversifying our staff? The number one step, I think, is to think strategically about where we're recruiting. Think about the way in which we're finding members of the organization or finding employees, and be willing to think outside the box. Have we historically relied on the same kinds of advertisements or the same recruiters? Have we historically just relied on referrals from employees or members of the organization already? If that's the case, we're probably missing out on a lot of opportunities. And think about how we might change that recruiting strategy so we're reaching different audiences. And to the extent that we're seeking to diversify based on race or age or gender, think about places that we might be able to communicate or reach out where folks in those populations might be more likely to hear what we're saying. On a related point, can we seek staff members of a certain age, gender, race, or sexual orientation that are otherwise missing from our team? The short answer to this is that we can seek that. We can have discussions about that internally. We can communicate about our desire to sort of improve or enhance our diversity. But what we want to be careful that we're not doing is that we're not saying our goal is to recruit a person who is fill in the blank. I think just talking about enhancing diversity in general, talking about identities that may be currently underrepresented in our organization, and the benefit of adding somebody from that community or a number of people from that community, all acceptable. But what we don't want to do is for lack of a better word, go to market or go to the recruitment process with the idea that we need to find a person who checks this particular box. Instead, we should think about casting that wide net, thinking strategically about where we might be able to find people who have different backgrounds than currently exist in the organization. And then if we identify a talented candidate who happens to be from one of these categories, we've satisfied what our goal here is. On the flip side, how do we address staff members that don't support these goals? I talked about how we've seen sort of, a notable increase in sort of reverse discrimination claims, or, short of litigation, comments on social media, public relations campaigns, where individuals are arguing that their employers are taking DEI too far, or they've, quote, gone woke. My advice is that, we treat all of our employees with respect. I alluded to the fact before that if you've got an individual who believes that they've experienced discrimination, even if it's a quote unquote reverse discrimination claim, that we take that seriously. You as an organization are entitled to require that your employees understand what your mission is and that we are all rowing in the same direction. It would be problematic, I think, for us to sort of decide to part ways with somebody because, they disagree with some of our efforts in that space. But to the extent that the employees or the individual's comments, made others feel unwelcome, or certainly if they rose to the level of harassment or discrimination, we would be entitled to take employment action against that individual. So I think using judgment and ensuring that the folks who are responsible in your organization for making and implementing those employment decisions understand sort of the nuances here is an important piece. And then finally, expanding that a bit to the board. Our board has a goal of looking like the community we serve. Can we recruit board members with that goal in mind? Well, the way that this question is drafted makes me very comfortable saying yes. We absolutely can think about recruiting board members to sort of reflect the communities that we serve. This is related, I think, to the second bullet, though, is can we specifically say, well, we need more women on the board. We need more young people on the board. We need more African-American individuals on the board. Those are appropriate discussions to have internally, but to the extent that we are thinking about recruiting, extending offers, adding, what I'm going to caution is that we stay away from sort of using that as the factor that we're deciding. Instead, if our goal is to add more African-American members to our board, think about whether we can plug into additional networks where we may be able to find candidates who are terrific for organization and happen to also be, representing a group of individuals who aren't currently represented on our board. So it's fine to sort of have those discussions globally, but when we're putting those plans into practice, I think we want to be careful to avoid suggesting that we're targeting somebody or selecting somebody based on one of those characteristics. With that, I'll turn it back to Jordan to talk a little bit about religious employers.
I appreciate it. That excellent work, Eric. And actually, if you don't mind, we have one or two questions that I may send your way first, if that works for you.
Of course, yeah, go ahead.
This is an excellent question that came in. It's come up before. Eric, you talked about employee resource groups and resource groups that support minority groups but are open to all employees for membership. So the question, of course, follows. Let me give you a hypothetical. There is an employee resource group for women employees, and you have a male employee who decides, well, I don't want to join that group, but if you have a resource group for women employees, you also need a resource group for male employees. Obviously, that's short of litigation, but there's a demand on the table. How would you suggest responding to something like that?
Great question. If we talk about it from a risk perspective, if you are going to offer employee resource groups for folks who have a particular group or a particular identity, my advice should be that you make the same accommodation available to somebody who wants to have a different sort of employee resource group. So in our hypothetical here, we could say, well, sir, who wants to have his own employee resource group, you are welcome to do that, and you're welcome to take the same steps that the leaders of our female or women's employee resource group did. We'll support you. We'll provide you with, access to, meeting space and communication internally if you want to be the one who gets that off the ground. So you're providing, I would say, the opportunity, but you as the entity or organization have no obligation to be the one facilitating that. So I think it would be wrong to say, if I have women's, I have to have men. If I have an African-American group, I have to have a white group. If I have a group that's in a particular class, you should be open to somebody who wishes to sort of create their own group for their own identity, but you have no proactive obligation to sort of start that, if it makes sense.
It does. I appreciate it. The last question I have for you doesn't come from this group here, but it's come up in the past. I always say that working with nonprofits and religious clients can be fun and unusual in the questions that you get that you wouldn't get otherwise. I have had questions coming in that said, well, we want our staff to look like the community that we serve and has experienced the programming that we serve. So for example, we'd like to hire someone who has experienced homelessness, or we'd like to hire someone who has been incarcerated. And I will freely admit, I'm not quite sure how to, how to respond to those requests. Do you have any thoughts about looking to hire staff members of a background like that?
Yeah, I think that's a really interesting question. And I would have two observations. I'll sort of have sort of the legal and the practical. The legal answer is that we're concerned from sort of an employment law standpoint only when the category in question belongs to one of the defined protected classes. So we've been talking about race and gender, disability status, age. These are all classes that are protected under the law. Someone's prior experience as an incarcerated individual or an unhoused individual is not a protected characteristic under the law. So I do not think it would be on its face problematic legally to offer or seek an individual with that experience. And second, from a practical standpoint, what we're getting at, I think, in that sort of question is, what is this person's lived experience? And that, well, I think in almost every instance, can be a very appropriate thing for an individual to take advantage of. And frankly, I think what some of the people who are challenging or pushing back against DE&I are saying, you're using race for a proxy for life experience, when that doesn't always line up. So why not instead focus on, I'm looking for somebody who has experienced economic hardship, or I'm looking for somebody who has had to overcome challenges. So in your hypotheticals, I would be pretty comfortable supporting an organization that wanted to have that as a component of what they were recruiting for.
Fantastic. One follow-up on the employee resource group question that I had. The question is basically this: what happens if an employer wants to kind of close off those meetings to members of a group because they feel like there are discussions that are taking place that are purely personal to members of that group? Is that something that's advisable or employers should avoid?
Good question. I think my default answer is that we would typically want to empower the members of that group to establish sort of the cadence and sort of the manner in which those meetings are conducted. But I think it would be problematic if we would say, okay, you are excluded from participating in this if you don't belong to this particular identity, for instance. So in your hypothetical, I think it would be acceptable for us to say members of the particular ERG are able to participate in the meeting or the call on a regular basis, and non-members of that ERG are not. But we couldn't, I think, put up a barrier and say you're only allowed to be able to be in the ERG if you have this identity, if that makes sense.
It does. Well, I appreciate it, Eric. There are a couple other questions that have come in, but I think Michaela's going to address that during her section. So let me shift and talk a little bit about religious employers, in which if you are a faith community or a religious employer or a college or university or healthcare organization that is related to a religious denomination or religious background, I'm not going to tell you to ignore everything that Eric said, but I will point you back actually to a presentation that Michaela and I did last year on employment issues for religious employers. I won't go through everything, but if you are in that position, two words that you should know about are ministerial exception, which is essentially an application of the First Amendment that shields religious organizations from any kind of judicial review of employment decisions regarding the selection, control, and removal of employees designated as ministers. So 20 years ago, if you would have asked, well, what is a minister? I would have probably said it was the lead kind of religious leader of a faith community. But over the last 15, 20 years, that definition has been expanded again and again and again by federal courts, including the Supreme Court. And the scope of ministers has expanded to include music directors, lay teachers, librarians, school principals, and others. In trying to decide whether someone is a minister, you should consider factors laid out by the Supreme Court in the Hosanna Tabor case, which is kind of the quintessential ministerial exception case, the title of the position, the training that they have, whether there's any formal commissioning. And I wish I could blame this on the Supreme Court. I can't. It's my own typo. That should be job duties rather than jot duties. All that to say, essentially, if you are hiring somebody in any kind of ministerial role, I think you can look at issues such as race, gender identity, sexual orientation, age. I mean, the court has expanded this to include disability and pregnancy status and other things like that. Not saying that you should do that, but it gives you a lot more freedom in being able to operate and make decisions about hiring, firing, disciplining ministerial employees without fear of courts getting involved in that. Now, that said, I'm going to shift from that to the next section on external considerations and pass the baton to Michaela.
Thanks, Jordan. I am very pleased to be with everyone today. As Jordan mentioned, we are looking at the external considerations. And those would be the external efforts by companies, nonprofits, educators, etc. As Eric discussed and explained thoroughly, internal considerations for DE&I policies and procedures are highly prevalent and are being scrutinized every day. However, since the landmark student affair admissions case, external initiatives have also become under scrutiny, and they're all over the nation, ending up in litigation. So that's what we're going to be looking at today. So, questions to consider. What we want to address today in this section of the presentation is whether an organization can support a certain group, such as females, entrepreneurs, people of color, the LGBTQ community, through programming, sponsorships, other financial support. Or what are those risks that we face? Another question that we hope to answer is, can we provide grants or scholarships? And what about hosting events with targeted audiences? So first, I've grouped these lawsuits into different categories. The first category is targeted programs. So we're seeing a lot of cases filed against organizations, companies, and nonprofits, specifically 40 cases since 2021 regarding programs intended to uplift and or benefit a marginalized, underrepresented group. And we see these targeted programs in the forms of scholarships, grants, fellowships, or internships. And we'll get into some of the case law and examples of those. The next section of lawsuits that we're seeing is what Jordan or what Eric was discussing earlier, is the workplace discrimination lawsuits. So cases where plaintiff is accusing their employer of discriminating against them because they are, for example, white, they're male, or belong to another majority or dominant group. Since 2018, one of the sites that I use to analyze these cases states that there are over 30 cases filed against for-profits and nonprofits for these workplace discrimination cases. So, lawsuits addressing diversity topics. This is a big classification that we are seeing a rise just in recent years. So, diversity targets cases in which a plaintiff challenges an organization's explicit goals to increase representation for marginalized or historically underrepresented groups in the workplace. We're also seeing, as the landmark students for fair admissions case that Eric went over, lawsuits against educators. So challenges to an educational institution's admissions process for due consideration of race or other identities. There's been quite a few of these cases filed, especially since and before the landmark case of students of fair admissions. The big topic that I wanted to focus in on today is diversity trainings. And again, we're seeing this as another category stemming up in courts. So challenges to an organization's employee education and training on DE&I topics, which goes to what Eric was talking about. These cases will really represent some of those targeted groups, some of those cases that we have seen within the last couple of years, especially since the landmark students of fair admission case. So the Fairless Fund case stems from the 11th Circuit Court of Appeals. And this is an example of a targeted program lawsuit. Here, a group of white males sued a venture capitalist company, a for-profit company, alleging that the company's grant program supporting majority-owned Black women businesses was discriminatory under Section 1981 of the Civil Rights Act. Section 1981, for those who do not know, prohibits discrimination on the basis of race when enforcing contracts. The 11th Circuit expressly held that programs that exclude certain individuals because of their race, such as the ones that Fearless had designed and implemented, were unjust and polarizing. However, this case with very parallel facts had a different outcome in Ohio, Federal Court of Ohio. Ironically, just 1 week before the Fearless case came out, an Ohio federal district judge found that a lawsuit, very parallel, white males who were suing a company for an initiative, did not have any standing and dismissed the case. The lawsuit specifically was against Progressive Insurance Company, which offered grants to Black-owned small businesses to purchase commercial vehicles. To me, when I looked back at the makeup of the court, and Eric hinted toward this as well, it's based on the different administrations. The varying rulings were greatly dependent on the judge and who they were nominated by. The 11th Circuit in the Fearless Fund was made up of a majority of judges who were elected by conservative Republican administrations, while the Ohio judge was elected by a Democratic administration. Cases similar to Fearless Fund are appearing throughout the United States challenging these targeted programs. So again, targeted programs mean, helping a marginalized group through some kind of funding. For example, like in Fearless Fund, was to provide money to help Black-owned women entrepreneurs. In American Alliance, this one was coming from Northern District of Texas, and this one was actually just filed a few months ago. Here, the plaintiff actually sued Southwest Airlines for providing free flights to students under a program called Lizante Travel Award Program. However, Southwest was limiting the program and the award recipients to Hispanic students. The plaintiffs alleged that this violated, again, Section 1981 and Title VII. This case was just newly filed. It's still ongoing, but the external initiatives by Southwest have been shocking and are readily cognizant all over the internet. In preparation for today, I actually looked up the 2023 posting for the Lizante Travel Program, which is the basis for this case. Back in 2023, the program said that Hispanic students who are currently enrolled are eligible for this program to receive travel funds. Today, though, if you look up this program right now, you would see that the program is actually only open to all applicants. And Southwest has expressly stated that eligibility for the program will not be limited to race, ethnicity, or national origin. So you see Southwest addressing this claim proactively in the middle of litigation in order to try to head off further disputes. Unlike the Southwest Lizante program, Pfizer has yet to make a change, and this just shows again that the differing judges' perspectives on this issue. So the Do Harm versus Pfizer litigation arising in the Second Circuit, which was filed in 2023, was about a group of plaintiffs challenging Pfizer's Breakthrough Fellowship program. This program was really a summer internship. The program was specifically designed to enhance the pipeline of diverse leadership within Pfizer. To be eligible for the pipeline program, a criteria would be that the candidate must identify as Black, African American, Latino, Hispanic, and/or Native American. The Court of Appeals upheld the district court's dismissal of the case on procedural grounds rather than substantive grounds. However, when I was looking back at this, even though it was dismissed on procedural grounds, Pfizer is still advertising right now for its 2025 Pipeline Breakthrough Fellowship for individuals who identify with that specific criteria. If the case was not dismissed on procedural grounds, it may have gone up and been ruled on the substantive grounds as to whether it was appropriate and or okay for them to look at and to specify a grant program, a fellowship program for a certain race identity. We are also seeing cases brought by employees challenging diversity targets. And Expedia is one of the cases that really caught my attention. This goes to the reverse discrimination that Eric was discussing. So in Expedia, a white heterosexual male was challenging Expedia's diversity targets within the hiring process. There, the plaintiff alleged that racial quotas illegally discriminated against him on the basis of race and sex under Title VII, Section 1981 in the Texas equivalent to Title VII. This could easily be translated to nonprofits who are seeking to have board of directors that are representative of a population that they intend to serve, such as race, disability, age. There are many organizations here in Kansas City where I'm located that do focus in on serving underrepresented groups, and some historically have represented groups that are based on race and ethnicity. These cases show that you have to consider the aspect in the legal ramifications as well. So the takeaway really is we're not saying these external initiatives are bad. Honestly, they have a great purpose. However, they are being challenged, and companies, nonprofits, educators should be cognizant of their initiatives, specifically within targeted programs and diversity targets. Until the Supreme Court takes up these issues with regards to nonprofits and for-profit companies, I would anticipate that split decisions will continue to be made throughout the circuits, truly depending on the judge and who the judge was nominated by. So recommendations. We want to leave you with some recommendations. And I think this should address some of the questions in the chat. One of the questions in the chat specifically said, how do you go about hiring or asking someone to join a board with a certain diversity without saying you are looking for such a person? So this goes directly to my first recommendation, prioritizing content-based eligibility. And it kind of goes to my second recommendation, which would be consider identity when it speaks to character. So first, let's back up to prioritize content-based eligibility. This is really looking at, instead of looking at the cohort based on a class, so race or gender, we're looking at them individually. So for example, this can be exemplified through a recent case against 3 law firms. The law firms were sued, and the plaintiffs said they were committed to not engaging in the program's DE&I objectives. The lawsuits were dropped after challenging the diversity fellowship for members of underrepresented groups. The firms ultimately changed their selection criteria to permit anyone to apply, not individuals who identified as a certain race or sex, so long as the applicant truly enforced and truly engaged in the DE&I policy set forth within the company. Here, the law firms were focusing less at demographic concerns and rather leaning into frameworks that emphasize the culture of diversity, inclusion, and belonging of others. So here, again, content-based eligibility would be emphasizing culture and diversity generally, rather than looking at cohort-based eligibility, such as someone's race, gender, age, etc. The second recommendation would be to consider identity only when it speaks to the individual's character. So again, going back to the students in fair admissions case from the Supreme Court, the court noted that while universities could no longer bump applicants up based on their race, they could still consider an applicant's discussion on how race affected their life. This same line of thinking could be applicable outside of the education context. For example, an employer or nonprofit could invite candidates or applicants to submit an essay describing how their identity has affected their lives. Here we're trying to stray away from strict numerical metrics for our targets and want to move more towards their identities and how that has affected the character or background of that applicant or candidate. Lastly, just generally, self-audit any kind of DE&I external measures that the nonprofit or the company is taking and determine if there are any risks associated with those initiatives. All of the recommendations that Eric discussed previously are applicable here as well. And if there are any questions, you see any of those risks, definitely feel free to reach out or consult an attorney on those as well. That's wrapping up my section. I'm going to turn it over to Jordan to talk about some special issues regarding religious institutions.
Thanks, Michaela. And I'll preface that by a question that I get quite often. So I'm a litigator by trade. And so I get a lot of questions from nonprofits saying, here's what we want to do. Are we going to get sued for this? And the answer that I always give them is, you can get sued for anything. Just because something is proper or appropriate or doesn't violate any statutes doesn't mean that somebody's going to file suit. But often I have conversations with clients about the idea of risk tolerance. You know, if you are a larger college or university engaging in a practice where there might be some sort of lawsuit, whether it's a reverse racism suit or something like that, some sort of discrimination suit, you're going to be a bigger target than a smaller, you know, community organization, 501c3. There will be considerations about deep pockets, and I'm sure there are some folks in higher ed that are kind of rolling their eyes at the idea of them having deep pockets versus other colleges and universities with 8, 9-figure endowments. So those are issues that may come up. The other thing that I often advise, and Michaela, kick me under the table here if I am wrong, but I don't know that this is necessarily a legal answer, but I always advise clients to consider what they reduce to writing. I think having conversations about idealistically what you want your employees, what you want your board, what you want your programming to look like, and who it serves and how you're using the funds that are entrusted to you, that can be a great conversation to have. It changes things, particularly if litigation is filed. It changes things if that is reduced to writing and you have it in your protocols or procedures or your bylaws or something like that, which kind of moves us into the last slide that I'm going to address, which is special cases for religious institutions. And I mentioned earlier, I talked about the ministerial exception as the two words you need to know. The other two words are ecclesiastical abstention. We'll give it three words and add doctrine to that. The ecclesiastical abstention doctrine is something that I've litigated quite a bit over the last few years, and it requires that if there is a legal claim before a court, and the court would need to resolve ecclesiastical questions, and by that I mean questions about what a faith group believes, or what a religion believes, or how it's organized, then the court must abstain from resolving those questions and instead defer to the religious entity's authority. So I've had questions from religious clients to say, well, if we were a regular for-profit or even a non-denominational non-profit, I might be worried about this. But as a church, as a mosque, as some other faith community, can we engage in this because it's what we believe? And the answer is, I don't know. Probably you're going to have a stronger argument than other organizations. But to me, the question is, does this ecclesiastical abstention doctrine apply to efforts that arguably involve DE&I, or would it protect a religious organization from DE&I litigation? Generally, my thought is you have if you read a lot of Supreme Court cases, a lot of focus on religious freedom, saying that religious organizations can't be forced to utilize their resources in support of things or people that they don't want to support. To me, the argument there is that the reverse should also be true, that a state or federal government shouldn't interfere with a religious organization's ability to utilize its resources in support of things that it does want to support. And kind of to the point that Michaela and Eric have brought up, a lot of that is going to come down to who you draw as your judge in this litigation. And I know there are a lot of in-house counsel on the call. Guidance that I always give is consider the judge. I've made arguments to more conservative judges on issues such as this, where I cite religious freedom arguments raised by the Federalist Society and in the legal journal of the Federalist Society. I wouldn't do that with judges that are more left of center or more progressive. Instead, I'd be focusing on the goals of the DE&I efforts and the impact that it has on society and the work that the nonprofit organization is trying to do. So I think even outside of the religious side of things, when you get into litigation, it's important to figure out who your judge is, what your judge believes, and how to present that case in front of that judge. Something to consider, particularly if you're a nonprofit, where are you located, and who is electing or appointing the judges that may have an impact on or may oversee or make decisions in that type of litigation.
Jordan, can I add one note kind of on a related topic there?
I would love for you to do that.
Yeah, it came to mind when you were describing that. There are two sort of particular strains of cases that we are beginning to see that implicate directly the religious freedom concept that you're describing and connect with this DE&I concept. So they are plaintiffs who are challenging either employer policies or training that relate to pronoun usage, or employer DE&I training that includes discussions of implicit or inherent bias. So there was one reported case where an individual brought a claim against his employer who was ostensibly requiring him to participate in a DE&I training that talked about the concept of implicit bias, and that all individuals have biases, may be racist in some sense, was the phrase that was used in the training. And he brought that claim, arguing that this sort of training or participating in that was inconsistent with his religious faith. He was ultimately unsuccessful in that claim, but we found it interesting that he was founding this concept of, a rejection of a different cultural perspective on religion. A related case that I thought was interesting was an individual making that same claim, or a version of that claim, in response to an employer policy that required employees to utilize an individual's preferred pronouns. The plaintiff in this case argued that utilizing male pronouns for someone who was born as a female, for instance, was inconsistent with his religious heritage. And in those cases, and we've had a couple of those instances come up when some of our clients, you kind of alluded to this before, the resolution is often seeing if we can find some sort of compromise. In that case, we were able to resolve that situation by figuring out whether that individual could simply utilize a person's first name rather than using pronouns in that instance. And could we resolve this conflict by doing that rather than creating these issues at loggerheads? But what I think was interesting, and I think both you and Michaela have suggested, is we have seen an expansion in the way certainly the Supreme Court and other lower courts are looking at the concept of religious freedom under the First Amendment. So I think it's smart for employers to be particularly sensitive when employees are raising those concerns.
It makes a lot of sense, and it's interesting to hear about that litigation. And another question that just came in, and I think it's a good one, is what about age discrimination? And this individual said, I notice in many annual reports that nonprofits have no directors over the age of 65 or 70. Is that asking for a lawsuit? I would say that is very unlike a lot of the clients that I serve, in which all of the directors are over the age of 70, which becomes problematic at some point. My suggestion in that, and Eric, I'd be happy to have you tell me if I'm wrong here, but generally, that is something that, in my view, a nonprofit organization should be considering. I think there are reasons to having avoiding turnover on the board, and some of that is bringing in younger people. I wouldn't go out and specifically state, and I wouldn't put it in writing, or would I say to people, we need a younger board member, or we need a board member under the age of 40, or anything like that. Again, that's something where I think you can have aspirational goals and discussions about what you want your board to look like, but I wouldn't necessarily include any quotas or anything like that. Eric, would you agree? Or am I off? Okay.
No, yeah, and to that specific question, the fact that a board may not have people who are older than 65 or 70 on it is not prima facie evidence of discrimination, in the same way that a board that may not happen to have someone for an underrepresented racial class is not discriminating as a result. You know, it may be a function of sort of, you know, the individuals who sort of fell into those slots. But another good reason to sort of, going back to what I said before, think about defining diversity broadly. If I'm putting together a team at a workplace, if I'm putting together a board, I want people from all different backgrounds and experiences, and that's going to include race, age, gender, life experience, however we define it.
Yeah, that's a conversation I have a lot when I meet with clients on board governance is, who do you want on your board? And it's not, some of it is, you know, somebody with a legal background and financial background, somebody who has used the services. Frankly, some of it is somebody who has a recognizable last name that can write a big check or get others to write a big check. There's all kinds of issues that you want on your board. And I think where I have seen nonprofits be really successful is in taking the time to kind of imagine what's important for the organization and what their board to look like as something that's kind of aspirational. I think it becomes problematic when they then include certain types of quotas in the bylaws, for example, because then you get issues. And frankly, I think that's often more trouble than it's worth. Rarely have I seen it invite litigation. I think it could, but I think the bigger issue is, for example, if you've got a 9-person board and you have that perfect person that you want to add to it, but that doesn't tick one of the boxes, are you doing your organization a disservice by requiring something that doesn't necessarily need to be required? All right. We're bumping up right against the 1 hour mark. I will say, as I've watched people come in, first of all, I'm grateful that there are so many of you that have joined. A lot of you joined later. I understand that sometimes happen when you do this over the lunch hour. So please know that tomorrow you should be getting an email that has a link. So if you showed up 5 minutes ago and think, oh, they really know what they're talking about, I want to watch the whole thing, you'll have a link to do that. We hope all the information was helpful to you. As a reminder, the program has been approved for legal education hours, so click on the CEU icon at the bottom of the screen to get what you need. Tomorrow you'll get that certificate of attendance and a recording, and you should get a short survey at the end of this. And again, we'd ask you to take just 30 seconds and let us know how we did, and also what you want to see in the future. We try to do 2, 3, 4 of these a year, and we base that based on the topics that you request. So that concludes our webinar. Thank you to Eric and to Michaela and everyone else for joining, and hope you have a great rest of your day, everyone.